Hello, everyone, and welcome to DOJ uses FCA to target DEI policies and anti-Semitism, the impact on government contractors. My name is Matt Feinberg. I'm a partner at PilieroMazza in Washington, D.C. I'm in our litigation and dispute resolution practice group, and I'm chair of the False Claims Act practice group here. And I'm joined today by my colleague, Sarah Nash. Sarah, you want to introduce yourself?
Sure. Hi, everyone. I am Sarah Nash, a partner in the Labor and Employment Group. I work in the DC office with Matt. In the employment group, we've been dealing with a lot of questions about DEI and recent executive orders that have been issued. So Matt and I, in our discussions, thought it would be good to have a tag up session, kind of looking at the intersections between the FCA and all of these new rules that we're seeing around DEI and employment practices. We are part of a larger firm. It's not just litigation and labor and employment. We have many other practice groups, including a focus on government contracts, uh, business and transactions, construction. The list goes on. These are all the lists. More importantly, just give a really quick legal disclaimer. Apologies for lawyers, it happens. Just letting you know that this is a webinar is not intended as legal advice. We're really just providing our thoughts on this FCA issue that's come up recently. And so what we're saying here is not entitled to attorney-client privilege. We are not creating an attorney-client relationship. But if you do have specific questions that you have about your specific circumstances, please feel free to reach out via email. We can also answer kind of high-level questions during the talk today. Happy to answer your questions in the chat as they come up, and we'll sort of navigate that as we go through.
So, as we move on to today's agenda, I want to sort of jump in really quickly and say, although the title of this webinar talks about the impact on government contractors, that's not really fair because this impacts more than just government contractors. It impacts any company that is receiving funds from the federal government. So, for instance, we're talking about institutions of higher learning. Universities, in particular, are a target of the government's new policies. We're also talking about grant recipients, which can be nonprofits that are receiving grants or, frankly, for profits that receive grants in some circumstances. There's a lot of grant programs in the United States government right now. Some are being terminated, but some are being expanded. And so don't just limit what we're saying here to government contractors. If there's money changing hands between the government and any person or entity, you have to think about the False Claims Act and how it impacts that transaction. And so, without further ado, let's talk a little bit about our agenda for today. We're going to give a brief, hopefully brief, overview of what the FCA is. Some of you who have attended our webinars before may have heard this before, but those of you who are new, it helps to level set expectations and give some context to what we're going to be talking about. We're also going to go through Executive Order 14173, which is ending illegal discrimination and restoring merit-based opportunity. We're going to talk a little bit about the federal and some state anti-discrimination statutes that are directly impacted by the government's and the Department of Justice's recent discussions about how they're going to be enforcing the FCA as it relates to DEI and discrimination. We're going to talk specifically about the government's new initiative, the Civil Rights Fraud Initiative, which is the actual program under which the Department of Justice is going to try and litigate DEI and anti-Semitism in the federal courts and try to claw back money from fund recipients. We're going to talk over some major takeaways from the program, and we're going to talk a little bit about risk mitigation strategies, things your company can do to help prevent liability or investigations under the False Claims Act, particularly with relation to the new initiative. So very quickly, what is the False Claims Act? Next slide, please.
Apologies.
And in short terms, the False Claims Act is the primary vehicle for the federal government to combat fraud and collect money obtained through misrepresentation or retrieve money improperly withheld from the government. And there are some key definitions that we talk about in terms of the False Claims Act. One is claim. What is a claim? It's a request for money or property, such as an invoice. And in some respects, it's a request for money or property that could have been issued. So when we talk about money withheld from the government, if the government doesn't know that it is owed the money, it might not issue a request for payment or an invoice, um, or, for instance, a demand for payment. But that would still constitute a claim, because if you're withholding the information, then if you had not withheld the information, then a claim would have arisen. When we talk about a claim being false, um, there are a couple of ways this can happen. Generally speaking, it means the claim to entitlement for payment was either improper, incorrect, unlawful, or unjustified. So that's when you submit a document and it is false, incorrect, it's asking for money not owed. But it can also include an otherwise perfectly valid claim that is supported by a misrepresentation. So truly, it means that there's something wrong or improper about any portion of that request for payment. But not all incorrect claims are violations of the False Claims Act. There's a very important knowledge requirement. And knowledge, when we talk about the False Claims Act, means actual knowledge. You knew that you were doing wrong, reckless disregard, and deliberate ignorance. And deliberate ignorance, sometimes a fancy word for saying you should have known. It describes sort of this ostrich principle, where someone put their head in the sand while a bunch of fraud was going on around them, and they said, "Hey, it's plausible deniability. I didn't see it, so it wasn't fraud, and it's not my fault." The False Claims Act does reach those types of circumstances, and ultimately, it's very broadly construed in the government's favor. All right, so next we're going to talk a little bit about relevant types of FCA violations, and I'm going to try and do this quickly because I've already given some examples. A false claim or false presentment is when a person or a company submits a false request for payment or a false entitlement to payment to the government. Now, this could be, for instance, an invoice for an incorrect amount, an invoice for work that wasn't performed, something along those lines. We also have a false record or false statement FCA violation. That is what I was describing before, when you have an otherwise perfectly viable request for payment, but it has been supported by a false statement or a false omission. We have things called express certifications and implied certifications. And one of an express certification might be something that you're required to sign off on or certify at the time you're submitting that request for payment. So, for instance, I've seen a lot of government contracts in my career where let's give you an example of construction contracts. There might be an affirmative certification requirement when submitting an invoice that says the funds received from this request for payment will either have already been paid to subcontractors, or the funds received from this invoice will pay subcontractors for all outstanding invoices. So that sometimes is an express certification. And if that statement is false, then you're creating a false record or false statement that makes the underlying claim for payment false and subject to the FCA. And then we have implied certifications. And those are things that don't show up on your invoices or requests for payments, but they are implied by the very nature of you performing as a government contractor or receiving grant funds. And that might be something like if you have a small business set aside contract, you are impliedly certifying every time that you submit an invoice that you are eligible to receive the contract at the time of your bid or at the time of award. So if you knew on the date of award and the date you submitted your bid that you are not a small business, then that would be a violation of an implied certification. A reverse false claim is where the government already has an entitlement to the money as opposed to the contractor or grant recipient. And one example for government contractors is where there might be an indirect rate adjustment. Maybe your G&A and overhead costs will have changed based on a new calculation of indirect rates, and you owe money back to the government as a result of that. But if you make a material misstatement in order to mislead the government into believing that it is not entitled to receive that reimbursement, then that would be a reverse false claim. Another instance I have seen is in the individual context is when in some states you can file these claims. A former government employee received an overpayment in their payroll. So due to a data entry error, instead of receiving $3,500 during their pay period, they received 35,000. There's just an extra zero tacked on. They then immediately quit their job, moved out of the country, and the government got a False Claims Act judgment against them for not returning the roughly $32,000 that they had been overpaid. And then we have a conspiracy claim, which is essentially two or more people working together, where at least one of them performs some act in furtherance of one of the other three options, either a false claim, false statement, or a reverse false claim. So the conspiracy catches everybody in the chain, even if they don't necessarily intend to defraud the government. You have that recklessness and deliberate ignorance standard where if they commit any act or come to any agreement within the chain of liability, then they can also be considered liable under the False Claims Act. So we talk, next slide. If we talk a little bit about false certifications, I've talked about the express and implied false statements. And these are very common that are in DEI under this new initiative, the Civil Rights Initiative. What we're talking about is the government creating, through the executive order, an obligation to make certain certifications, essentially that you are in compliance with federal civil rights laws. But in addition to that, the initiative, even if an agency forgets to include that requirement in a grant application or grant document in a government contract, what the government is trying to do is create an implied certification requirement that all recipients of federal funds are in compliance with civil rights statutes, that they do not have illegal DEI programs, and that they are not engaged in actions that would constitute anti-Semitism. So we're going to talk a little bit more about this in depth, but these are particularly relevant issues to the initiative. That raises the issue of contract noncompliance. So you may have a contract that requires the certification of compliance with civil rights statutes. You also might have a contract that requires you to involve yourself in practices that government considers to be discriminatory. And we're going to talk about that a little bit later. And then one final issue that is relevant under the FCA is a retaliation claim. And this is going to be important in the whistleblower context, because if an employee or an independent contractor or a vendor suffers some sort of adverse action by the target of an FCA claim based on their participation in the investigation, their disclosure of information either to the company or to the government, or other participation in a False Claims Act matter, then the contractor or the grant recipient can also be liable, in addition to all of the other False Claims Act liability that might arise out of their conduct, for specific retaliation as to that individual. And with that comes some pretty harsh penalties, which includes double back pay, emotional distress, pain and suffering, attorney's fees, costs, things like that. Before we go to the next slide, I do want to talk just a little bit briefly about the impacts of the False Claims Act in general. And the reason this is such an important statute to the government and such a dangerous statute to anyone who's doing business with the government is because it includes very strict and harsh penalties. when you have a violation of the False Claims Act, the statute provides for as much as treble damages, and those treble damages are mandatory as to the damages found by the jury or calculated as part of by a judge or as decided through a settlement. So, if, for instance, an entire contract is subject to illegal discrimination in the eyes of the government, then it's possible that that contract, the damages under the False Claims Act, those contract damages would be tripled. In addition, there's also a penalty assessed, mandatory penalties per false claim. So usually that's per invoice or request for payment of anywhere between $13,000 and about $27,000 per invoice. That penalty goes up every year. So that's why I gave you a big range, but it can fall anywhere in that range. And then if there is a whistleblower involved, you've also got the potential for attorney's fees and costs. So we talk about the importance of the False Claims Act to people doing business with the federal government. We're talking about the potential ramifications financially and reputationally that can significantly damage or perhaps put a company out of business.
Thanks, Matt. So on that note, FCA, yes, does have a lot of potentially very terrible consequences. And we are marrying that whole concept with the new initiative that the Trump administration has put out on ending illegal discrimination. And I'll just say, as we start this conversation, there's a lot of unknown out there. First of all, we've never seen the FCA applied in this way. We've never seen an executive order that takes this approach. And so that means there are a lot of firsts, which also means there's just a lot of uncertainty. We are hoping to receive additional guidance in the coming months on some of these issues, some of what's happening, but a lot of it's going to kind of be play it by ear, see what happens. To that end, I'm going to go over what we know about Executive Order 14173. There is a lot of uncertainty, like I said. I don't have all the answers, but I can tell you how agencies have been looking at this, how courts have been looking at this, and how we've been looking at this, and how we've been advising our clients as they kind of go through this new time where we're trying to figure out exactly what the administration is targeting. What we know about Executive Order 14173 is that it targets illegal discrimination. What we don't know exactly is what illegal discrimination is. We've received a little bit of guidance over the past few months since this was issued in January. We don't have complete insight into what's being targeted, but I'll go over some examples of what is okay, what's not okay. But what we know for sure is that one big part of this executive order was that it revoked a prior executive order, 11246, which was issued back in the 60s, actually. And 11246 basically implemented what we know as OFCCP, Office of Federal Contract Compliance programs. It implemented certain obligations on contractors to have affirmative action plans for women and minorities. And it kind of created this mechanism for reporting discrimination on the basis of race, sex, national origin, through a separate channel from the EEOC. Folks on the call, HR professionals, might be very familiar with the EEOC, everything that it does in investigating charges of race discrimination, sex discrimination, and those Title VII offenses. What the OFCCP did was they also took a part of that, but for government contractors. What this new executive order from the Trump administration has said is it's basically stripped OFCCP of a lot of its powers because it revoked EO 11246. It makes it unlawful to create these AAPs for women and minorities now. If you guys are unfamiliar, an AAP is basically a plan that contractors with over 50 employees were accepted to put in place to ensure that they did not have indirect or implicit bias against certain genders or certain minorities. And the way it worked is generally you would get all this data together for who you're promoting, what your workforce looks like, how it's spread out, the type of industry you're in, and you would compare that to the census in your area to see if you're really matching up with what your local makeup of available employees looks like. And you compare the two and see if there are any changes you need to make. So, for example, if you have only 13% women employed, then you look at the census, it turns out that there are 50% of applicants are actually available and are women. Your AAP might direct that you need to spend more time recruiting and looking for women in your workplace. The EO that the Trump administration issued this year basically stripped that obligation and went a step further in saying that type of focus on applicants or employees on the basis of their race or sex is unlawful. And so there have been a lot of folks might be familiar with this in your own workplaces, a lot of steps away affirmative action plans, steps away preferences depending on race or sex, and trying to focus instead on just sort of ignoring the race or sex of the workplace. We are still waiting for a FAR clause that sort of fills in some gaps. We're hopeful that the FAR Council will issue that, but there's still a lot of unknowns. What we do know, which we've picked together through looking at various memos and court cases, is that at the end of the day, we are talking about preferences on the basis of a protected characteristic. So it's unlawful, for example, to say, I'm going to hire this individual because they help with our complement of employees. We want more individuals of color, and that's really important to us. Those preferences are illegal. And just to be clear, it's not as though hiring someone because of their race or because of their gender was something that was illegal previously. It's just kind of the focus here. And so that's leading to some confusion. If it's illegal before, it's illegal now, what's the difference? Where are these definitions coming from? And there have been some court decisions that have come out of this. Initially, this executive order was enjoined by a Maryland court. It was shortly thereafter lifted, the injunction by the Fourth Circuit, basically focused on this question as, do we have enough information based on this executive order to really understand what's unlawful, what's not? And what we've been sort of advising clients is, generally, if you have a preference in your policies for a certain race, certain gender, certain sex, that should probably come out. There are some companies out there that use sort of focus on, we really take pride in the fact that 50% of our employees are women, or we take pride in the fact that we are seeking out certain minorities to help make sure that we have a perfect complement for diversity. Those policies are probably a no-go under the Trump administration. But on the flip side, everything else that companies have been doing with respect to anti-harassment policies, non-discrimination obligations, those are all still in place. And arguably, we'll talk a little bit about this between Matt and me, they're even more important now because of the certification requirement. Because while the Trump administration has been focusing on these sex-based preferences, the way that this is drafted is so broad that it necessarily sort of swallows up everything else that goes hand in hand with sort of discrimination or illegal preferences. So in other words, we're looking at Title VII discrimination, but we're also looking at the ADA discrimination, Americans with Disabilities Act. We're looking at the ADEA, age discrimination in employment. And so I'll talk a little bit about why those policies and procedures that ensure no harassment or that ensure no discrimination in the workplace are that much more important. Even though the Trump administration is focused here, Matt can talk about how he's seen plaintiffs' attorneys really honing in on this idea that, oh, now I can add on an FCA claim if I have a discrimination complaint. I'll also add that, because I mentioned the injunction by the Maryland court. That court case is still ongoing. We have yet to have a final decision. But meanwhile, the Supreme Court, folks might have heard, or was it last week, issued a decision that made it very hard for a district court to enjoin a federal agency nationwide. And so we're going to see how that Supreme Court decision influences this stuff. But for the time being, everything under Executive Order 14173 is in place. We've started to see certifications. I'll show you some sample language that we've seen, although really those should not be issued until the FAR clause is finalized, but we have seen primes and agencies issuing that. So I'll talk a little bit about that. I've got a little bit of questions come in, so let me make sure I don't hop over someone's
Yeah,
question.
Sarah, I'd love to pose a question to you, Sarah.
Please.
Came into me. So, how would a government contractor, grant recipient who is obligated to respond to or make representations and certifications, or what we call reps and certs, related to AAPs? So, whether that's at the time of submission of a bid, at the time, sometimes you have to make those certifications in your SAM, System for Award Management profile. What are your recommendations, if any, about how to deal with that reps and certs problem?
Yeah, it's really frustrating, right? Because for whatever the reason, the reps and certs have not been revised yet, so they still have that obligation to comply with those AAP requirements. What I've been telling clients is, well, okay, first of all, let me start with the answer. What I've heard from agencies, they are to ignore that question. So they are not supposed to focus in on the response to that. It's as though it has been stripped from their end, so they're not looking at it, but still I recognize that it's appearing for you folks. I've been telling people to answer, we do not have an AAP in place. The reason I'm saying this is there's been a lot of buzz within agencies, within the administration, that they are targeting contractors now who have a legal DEI, who still have their AAPs for women and minorities in place. And I don't want to give them any additional ammunition to come after a contractor who says, oh, yes, I'm compliant, I have my AAP in place. That said, I've also had clients say, well, we asked our contracting officer or we asked our representative and they said, yes, go ahead and answer this way. So I don't want you to do something inconsistent with what you've been instructed by your agency. But generally, yes, I would not admit that you have an AAP in place. Obviously, there are ways to go back and if you need to, but again, agencies should not be paying attention to that particular representation and cert. So I think ultimately, whichever answer you put, it does not influence your eligibility for the award.
The one thing I would add to that is if you are required to produce those reps and certs with regard to a specific contract and you have space in your proposal or in the reps and certs page to submit clarification, you can mention that, for instance, uh, uh, you do not have the required AAP, because keep in mind the representation and certification is asking you to confirm whether you have AAPs. Sarah's recommending you say no, but if for some reason the government has used old language for a specific contract and is asking for AAPs, and you're getting an instruction from the government, then you'd want to clarify that in your submission and say, in compliance with the government's instruction, we are checking yes to the AAP box. The other thing you can do is you can submit a Q&A for consideration during the proposal process to ensure that the government is telling you exactly what you have to do. And the reason this is important is because you want that paper trail. If the government instructs you, the agency instructs you to say yes to the AAPs, and the government then comes after you later, the Department of Justice comes after you later and says, you've made an admission that you have an AAP, and that's a violation of the executive order and of federal policy, then you will at least have that paper trail and say, yeah, but the reason I said yes is because the government told me to, And here's the place in my proposal where I specifically said I'm in compliance with the law with regard to AAPs. So that's what I would add. That was a long-winded way of saying, yes, I agree, do what the government says, but try and create the paper trail and keep notes. And if you can't fit it into the proposal, make sure that you have a contemporaneous document that certifies your compliance with discrimination laws, so that if someone comes after you later, you have that document dated to show them that you were in compliance at the time you submitted your proposal.
That's great advice, Matt. I see another question in here about whether these particular restrictions are being applied to small business activities. For the time being, no. The SBA and the set-asides were created through statutory mechanisms, which makes it, in theory, a lot harder for the administration to target them, although there have been certain examples of how those particular programs are being targeted. But Executive Order 14173 really is just strictly focused on these AAPs and hiring mechanisms. And the reason that they're able to go after these in large part is because 11246 was not a statutory law. It was implemented through an executive order, so it's a lot easier to take away executive orders with executive orders, and then you get into sort of the hierarchy of laws versus regulations and executive orders. But that's why, for the time being, that this does not apply to the small business set-asides. Okay. So that's just a quick intro. Again, a lot of this stuff is frustrating because we don't have complete transparency, but we do have some sort of historical ways to look at this, look how anti-discrimination laws have been applied in the past, look at how the EEOC approaches these questions, and courts, because at bottom, really, all of this is saying is that you are supposed to be complying with anti-discrimination laws, and that you are promising that your DEI activities don't violate those laws. That's basically what the sample certification language that we've been seeing says. There are two pieces to it. One is that a contractor or prospective offeror confirms its compliance in all respects with all applicable federal anti-discrimination laws, is material to the government's payment decisions for purposes of Section 31 USC 3729B4, which is the False Claims Act, reference to a material misrepresentation. This Matt discussed a little bit at the top of the hour about how the FCA applies and why it's important that you have a material misrepresentation as part of that. Up until now, generally, your violation of certain statutory requirements has not been something that is material to the government's payment decisions. I think there's some questions as to whether we haven't seen any FCA cases come out of this yet. So again, we don't still know exactly how it's going to roll out, but at least according to this DOJ initiative, they are going to be looking at enforcing this mechanism. There is a question, as always, how far does this go? We've been telling folks who do see sample certification language in either their subcontracts or from agencies to get in front of an attorney before you sign, because of the implications. If I saw a certification language like this, I probably wouldn't be too concerned, other than the fact that you do have to make sure that you have good policies and procedures in place that ensure that you are complying with the anti-discrimination laws. We'll talk a little bit about how to sort of mitigate the risk there. But generally, this is what we've been seeing. If you see something that differs significantly from this language, again, a good idea to pick up the phone and call someone, because there are some folks who are expanding upon the requirements, and you don't want to end up certifying to something that's not necessarily required by law. Part of the reason that this is such kind of a headache from a labor and employment perspective is there are a lot of labor and employment laws out there. There are a lot of equal employment opportunity requirements. part of the questions that we've been receiving is, does this mean that I can get rid of my EEO policies? I shouldn't have those anymore, right? The EEO from the Trump administration says we're not supposed to pay attention to race or sex. Great, done. No, absolutely not. These policies are even more important now that there is a certification that you are complying with them. As you can see here, again, HR professionals, hopefully you know all these acronyms. If you're not particularly in the HR field, I apologize, but also good to know these. You've got Title VII, which is your classic discrimination protections for sex, religion, race, gender, color, the list goes on. You've also got the ADA, which protects individuals with disabilities. You've got the Age Discrimination in Employment Act. You've got USERRA, the National Labor Relations Act, FLSA, FMLA. All these laws relate to anti-discrimination in employment. And so it's very important that you have policies and procedures in place that not just protect employees from discrimination, but have a good reporting mechanism, a good complaint policy to make sure that employees are reporting these issues to you directly, instead of going out and maybe finding an FCA attorney to talk to instead. I'll also mention that there are very specific state law considerations at play, including certain state laws that do require still affirmative action plans. There is some tension between these state requirements and the executive order's ban on affirmative action plans for women and minorities. What we generally recommend is that you follow the state requirements. There are some decent arguments that the federal requirements do not expand to legally obligated AAPs under state requirements, but happy to talk about that more offline if people have specific questions. Often it's in specific industries. You might see maybe in the construction world, there are some specific state requirements. I know Minnesota has some requirements, as does California and New York, I believe. Just really quickly, it's not the focus of today's webinar, but it is helpful as people are sort of evaluating their AAPs. Not all AAPs are created equally. The VEVRA obligations and the individuals with disability obligations for AAPs are still in place. Again, probably because these are statutory, not created by other executive orders. So those obligations to have an AAP for veterans or have one for individuals with disabilities still apply. Generally, these obligations are only going to apply if you have at least 50 employees and your contracts meet a certain dollar threshold. I will say that for the time being, the VEVRA, that's the Veterans Requirement Hiring Benchmark, remains in place. That's a benchmark that's set at about 7%. There's supposed to be a benchmark for companies to hire approximately that same number of veterans. That is still in place, but the Section 503 for individuals with disabilities, there is a reg out there that proposes eliminating another 7% utilization goal. So we're going to see how that plays out. It just means that your AAP processes and procedures, at least under 503, might change in the near future. Just important to keep an eye on that. Previously, OFCCP had stopped regulating or policing the 503 and VEVRA AAPs. They just announced that they are going to begin doing that again. I'll also mention, just as we're going through this flurry of changes, OFCCP, at least according to the latest budget proposal, is soon going to be absorbed into different agencies. So it's looking like different parts of DOL is going to take over their OFCCP responsibilities. So they will be enforcing these AAPs. We've also recently seen guidance that says that they are looking into former AAP practices, but we haven't really seen how that's going to play out in reality. So still seeing how that goes. Matt, you're going to talk about a little bit about the Civil Rights Fraud Initiative on the heels of that.
Yes, thank you. So about 2-ish months ago, a memorandum was issued by the Department of Justice launching a new FCA enforcement program called the Civil Rights Fraud Initiative. The government believes, essentially, this memorandum establishes that the government believes that the FCA is implicated when a federal contractor or recipient of federal funds, like a grant fund recipient, knowingly violates civil rights laws and falsely certifies compliance with those laws. The memorandum gives a few examples, and the ones that are mostly relevant to government contractors are engaging in racist preferences, mandates, policies, programs, and activities, including through DEI programs that assign benefits or burdens on race, ethnicity, or national origin. What we're talking about here is illegal discrimination. And we put illegal in quotes because it is really difficult, like Sarah said, to determine what is illegal. There are some other examples here for non-government contractors, but they might touch a little bit on government contracting. For instance, the memorandum specifically talks about transgender women playing sports with those who are born biologically female. That is a direct attack by the Trump administration on universities that have permitted transgender individuals to play sports in the sex that they have transitioned to, as opposed to transitioned from. There are also comments about universities or companies that allow, and I'm using the memorandum's terms, allow men to use women's restrooms. Again, this is the Trump administration's political focus on transgender women being permitted to use women's bathrooms. That one is primarily focused on universities as well, but it does impact government contractors. If a government contractor is potentially using a facility for government contractor employees that allows for transgender women to use women's bathrooms, then in theory, the government could deem the contract to be falsely obtained and to include an illegal DEI program, and therefore violate the False Claims Act. So we are talking, the key takeaway here is how do we know whether something is illegal discrimination? It involves, for instance, when we talk about how a company should treat transgender workers, is it even appropriate or fair to ask a transgender worker whether they are transgender? Whether the bathroom they are using is the one of their choice or the one of the sex they were born into. These raise a lot of issues that are very complicated for companies and particularly for HR directors. And so this is a difficult initiative to navigate for government contractors, for grant recipients. And we're going to talk a little bit more about the initiative and how to navigate it in a few seconds. Next slide.
Now, I'm just going to jump in there as well that remember, state laws still apply. So there are a number of states that protect gender identity. In fact, there's a Supreme Court case that considers gender identity to be part of the sex discrimination question. And so it's not as simple as just, ignoring these gender identity issues. You want to kind of treat them the same way you would any complaint that comes in. When someone complains about discrimination, and make sure that you have investigated whether there are other options, for example, using a private restroom on the work site, although that's not always, as everyone knows, the flexibility that can be afforded. Okay, next slide.
So the ultimate purpose of the initiative is undoubtedly to target DEI and anti-Semitism, which serves the Trump administration's policy goals of driving diversity, equity, inclusion out of the federal government and federal contracting space, and particularly out of higher education. The timing of this initiative coincides with the Trump administration's interactions with Harvard University in particular. And so there is some speculation that this initiative was designed really to threaten universities, including Harvard, including other Ivy League schools, which have not, to the Trump administration's satisfaction, prevented protesting on grounds related to the Israeli-Palestinian conflict. So Sarah touched on this earlier, but this is a very broad initiative. It's so broad that it raises what I would call wonky threshold issues. For instance, should the FCA be used to further policy goals that are specific to an administration or political party? One would argue no, some would argue yes. The reality is that the initiative itself is so broad and circular that it is difficult to enforce and difficult to comply with. As we've mentioned a couple times, it targets illegal discrimination. So there can't be an FCA violation until the underlying practice is determined to be illegal. But that can't really be done until a jury or a judge or an EEO administrator has evaluated the policy or practice and determined it to be in violation of a federal statute. But there's a lot of issues that can cloud whether a practice is illegal. For instance, under the Americans with Disability Act, you can have an individual who has a disability, and that person cannot be terminated so long as they are able to perform the vital obligations of the job with or without a reasonable accommodation. If a person cannot perform their job duties with or without a reasonable accommodation, then a termination of that employee, even one based on their disability, is not itself illegal. And so there's a lot of moving parts to every decision. And then we're going to touch on this in some of our mitigation factors upcoming, but it just is a very difficult initiative to ensure compliance. It's a very difficult initiative to enforce. And it seems virtually impossible to accurately evaluate in real time whether a company or a government contractor or grant recipient is actually compliant with federal civil rights law. It's also likely to have impacts contrary to the purpose for which the Trump administration has announced it. For instance, it's expanding FCA liability to claims where minorities are claiming workplace discrimination. That would theoretically create an FCA violation under this initiative, but it's not what the Trump administration or the Department of Justice was intending to do when it created the initiative. And if you go to the next slide, this is a pretty key takeaway from the vague language and broad language of the initiative. Violations of federal anti-discrimination laws rarely have led to FCA cases in the past because the garden variety violations of law or regulation alone are insufficient. They tend to be very fact-based, and so no one can knowingly violate the FCA if they aren't sure whether their violation of some civil rights statute is definitely illegal. And historically, a statutory or regulatory violation would only confer FCA liability if it was the subject of an express or implied certification in the government contract or grant that was involved. And so that violation can only be material if it's relevant to the work performed under the contract. That's a difficult burden to meet when the purported discrimination isn't tied at all to the work performed. If it's a construction contract and there's an allegation that, for instance, the contractor was hiring illegally based on DEI, is that DEI program ultimately tied to the contracting purpose, the construction of the building or the renovation of the building? And if there is a violation of some civil rights statute, does the contracting officer care, or would they continue to pay for the work being performed even despite that discriminatory action? That means, in theory, if they would, that it wasn't material and doesn't create a False Claims Act violation. So I've given you a lot of information in a very short period of time. All of it probably seems pretty contradictory to itself. And that's because this initiative is super broad, very hard to comply with. Sarah, you want to talk a little bit about the impact of the initiative with EO 14173?
Yeah, and Matt, I think you hit the nail on the head. It's just a lot of question marks. I will add that we've seen a little bit of this in whistleblower world. Under the NDAA, there are certain protections for whistleblowers who disclose violations of waste, fraud, or abuse on a government contract. And we've seen examples where employees have alleged sort of whistleblower retaliation because they disclosed a sexual harassment incident. Although often it's found not to be, particularly material to the contract. I'm just adding that this is not the first time we've seen sort of this question of discrimination kind of bleed into other traditional contract questions. So it'll be interesting to see how that shakes out in the coming years. Um,
So, on this second key takeaway that piggybacks on what Sarah was saying, the memo itself encourages whistleblowers to file key tam suits. And a key tam suit is essentially a False Claims Act suit filed by a whistleblower. Um, and when the government encourages whistleblowers to file lawsuits, they're essentially giving carte blanche to the whistleblower to come up with theories that will allow False Claims Act liability. Well, where is this going to go? It means that a garden variety Title VII allegation, for instance, someone has discriminated against someone else in the workplace, maybe there's been an allegation of sexual harassment. In many respects, plaintiffs and plaintiffs' attorneys are going to immediately tack on a False Claims Act claim to a standard garden variety sexual harassment claim in order to increase the amount of damages that can be recovered. Let's take, for instance, a wrongful termination case where an employee receives a new job a month later. In that wrongful termination case, let's say that they've alleged that they were discriminated against because of their religion, their damages are going to be relatively small. Now, they certainly may have some pain and suffering or emotional distress, but their job related damages are going to be pretty limited to the 1 month of pay that they lost because they got the new job. But in the False Claims Act context, what we're talking about is potentially 3 times the value of the contract. We could be talking about hundreds upon hundreds of times with the damages that a plaintiff's attorney can claim in a False Claims Act suit as compared to an unlawful termination suit. And so, what plaintiff's attorney wouldn't try to add these FCA claims to an employment discrimination case or another violation of civil rights statute? And frustratingly, there's not a lot that defendants are going to be able to do about it other than defend the cases. You know, at first, when I started thinking about this, I thought, no way, I'm blowing this out of proportion. Like, there's no way that this initiative is going to turn every Title VII case or every discrimination case into an FCA case if it's filed against a government contractor or a grant recipient. And then 2 days ago, I got invited to 2 separate webinars conducted by other companies that are telling me and hoping to explain to me how plaintiffs' attorneys can add False Claims Act liability to their garden variety employment discrimination cases in order to increase damages. So I guess in one sense, I was right that this is a possibility. And in one case, it's really sort of disappointing that this is what this initiative, which is clearly not the intention of the initiative, is going to lead to.
So our last takeaway relates to DOJ's position on what constitutes wrongful conduct, makes compliance really difficult, and we're probably going to see a lot of inconsistent enforcement. We got one question asking about whether we're going to see investigations or actions taken as pretext for political activities. Matt, you might have additional feedback on that. I think the bigger risk is that we're going to have, you've got so many different states out there, different courts. There's going to be a lot of disagreement over what exactly constitutes a false certification or a false implied certification. And there's going to be a lot of individual courts probably making decisions on these pieces. The DOJ memorandum does explain that they will use the FCA to, as Matt said, weed out illegal discrimination. We don't know what that is exactly. Generally, it's going to be taking adverse action against an employee because of their race, national origin, sex, or religion, failing to address sexual harassment in the work environment, failing to engage in an interactive process. Matt talked a little bit about the consequences of, you know, discriminating against someone on the basis of their disability. And those are the pieces, honestly, where companies can really focus. I'd say it's really important. We have a few, I know we're coming up on the end of the hour that we have, but we're going to go through some best practices that will hopefully help companies stay out of hot water, elevate decisions to your opinion. You can't always stop discrimination in the workplace. The important question is how you respond to it and how you have mechanisms in place that are, you know, best practices so that you as a company are not going to be liable for bad acts that are going on. And it's going to be very fact specific. It's sort of like this EEO world. It all comes down to very specific facts and circumstances. I'll talk a little bit about why it's really important that you offer training to your managers if they're in a position to impose discipline, because that is often a hole in company practices. At the very top, everybody knows the rules, but some of the middle management folks don't apply them consistently or best practices, which ends up blowing back on the company. I will also add that the OFCCP recently on June 27th offered some examples of what illegal discrimination is. To Matt's point, they're really talking about two different things. They are not talking about the traditional discrimination on the basis of race, sex, disability, et cetera. They're really focused on this preferences due to race or sex. And it's going to be interesting how these two concepts are married together as we move forward. Okay, I think that takes it off on the takeaways, unless you have anything to add,
Nope,
Matt, and we're going to jump.
let's go ahead and move on to risk mitigation. So
Perfect.
all is not lost, everybody. I do want to point out one thing, that the hallmark of an FCA case is what the individual, the defendant's subjective beliefs were. So if you truly did not intend to, or know, or were not reckless or deliberately ignorant of alleged illegal discrimination, that is still a defense to the FCA. And that's a really important takeaway, because it's not just that there's some automatic liability when there's an improper termination.
Excellent point. So let's talk a little bit about what you can do as companies to mitigate this risk. And as Matt mentioned, the knowledge factor is a really big piece when it comes to how you're looking at these policies. You should everyone on this call, to the extent that you have a company with employees, should have either a handbook or individual policies and practices in place that plan for a potential discrimination complaint, sexual harassment complaint, retaliation complaint. Your policies and practices are a big part of your compliance with these requirements, because they tell employees where they should be directing their concerns, who they should talk to, and what practices will follow. So, for example, if you receive a complaint of discrimination on the basis of sex, there should be a process whereby the employee knows exactly who they can report to. They know how the investigation will be completed, and they are apprised of the outcome of that investigation. That is a very easy way to mitigate risk when it comes to unlawful discrimination. You also, we go through, and I know we're coming up against the end of the hour, but there are a number of changes that you can ensure in your policies that are also going to be complying with these new requirements. One, you want to make sure that your affirmative action for women and minorities is gone. The only affirmative action plans you should have in place are for VEVRA and the Rehabilitation Act. You want to make sure that you are revising your applicant tracking requirements. Applicant tracking and self-identification processes are no longer required if you have fewer than 100 employees. EEOC has its own requirements for EEO1s if you have more than 100 employees, so that remains in place. And then you want to make sure that you are reviewing your recruiting processes, ensuring that you don't have quotas or preferences, evaluating internal processes that impact your terms and conditions of employment. You want to update maybe your EEO statements to the extent that they reference AAPs for women and minorities. And just make sure generally that your policies and procedures are up to date and appropriate.
All right, so moving on to risk mitigation strategy number 2, we're down to the nitty gritty. We've got like 2 minutes to give you the nuts and bolts of it all. So Sarah touched on this a little bit. Complaints about discrimination, preferential hiring, the existence of illegal DEI, complaints about even bathroom use and inappropriate relationships, things that can lead to complaints under civil rights statutes. They have to be taken very seriously, and those complaints must be investigated thoroughly. But what happens when an HR director or a company executive is the one doing the investigation? Or even worse, the complaint is against the HR director or the executive. You want to be able to retain competent counsel outside the company to assist or conduct these investigations and provide privileged reports to company leadership. If someone inside the company could be accused of being sort of on the take for an executive who's accused of wrongdoing, then that opens up the potential argument that the investigation wasn't thorough and that it was just sweeping illegal discrimination under the rug. If there's a legitimate risk that conduct may have violated a civil rights statute, government contractors and grant recipients may wish to consider voluntarily disclosing those events to the government. Because if you would disclose them to the government in accordance with various procedures in the FAR, then you're sort of giving yourself a backstop. The government is not going to terminate your contract 99% of the time unless the discrimination is particularly egregious. And they're going to know about the alleged claim of discrimination, so that if there's a False Claims Act claim later, then it would not be material to the government's decision to continue with the contract. And then if you have located potentially discriminatory policies or procedures where concerns have been raised, you want to cure them promptly and with a very significant paper trail in order to avoid scrutiny in an FCA case. Sarah, you want to wrap up for us?
Yep. And I think I always do this. I sort of spoil the future slides, but really just emphasize the importance of strong EO policies, strong anti-retaliation policies. Generally, you're going to want open door policies that encourage employees to bring concerns to you. If they don't have a mechanism for that, this can often be difficult when you've got a government contract where your employee is regularly working with government personnel, but you want to make sure that they have your policies and procedures and they know exactly who they should be going to if there is an issue. You also want to stay up to date on, we've talked a lot about how these are shifting legal obligations in the courts, or whether it's regulations or guidance. You want to make sure that you're up to date on how these things are changing, up to date on how your contracts are changing. We received one question about taking out certain FAR clauses or EEO and affirmative action provisions. Certainly would encourage everyone to take a look at those and walk back any clauses or EEO obligations that refer to AAPs, other than, of course, your veterans and disability requirements. And there are some obligations to keep those statements in your EEO statement, so make sure that those are up to date. And then lastly, don't forget that questions are a good thing. Matt mentioned this when we were talking about RETs and certs. It's always a good idea to make sure that you are communicating with your agency or the contracting officer to make sure that you understand your obligations and have that line of communication open.
If we did not get to your question today, we'll put our contact information up here on the screen for you. You can reach out to us by email, and we'd be happy to talk about your specific circumstance. We appreciate you joining us today. Hopefully, we'll be doing some more webinars on this same topic as we get more information from the Department of Justice and the government. But if you have questions for us, feel free to reach out, and we'd be happy to talk about the Civil Rights Fraud Initiative, the executive order, or any of the topics we've discussed today. Thanks again for joining us, and we hope to see you next time.
Bye, everyone.